Tonight on Nation and Nation, hope that the proposed First Nations child welfare settlement leads to change. For plaintiff Zach Trout, money can erase the trauma his family suffered, but reform can help prevent it for others.
That's the reason why I took a stand, because I still see children that are still suffering today, which they shouldn't be.
Compensation will also benefit Jeremy Miyawasagi, another plaintiff with complex medical needs, according to his brother, Jonathan.
He would get the extra things that he would need to, like, stay at home.
And the federal court says the Mounties broke the law by failing to address complaints for years and must now respond quicker. It's a win for RCMP oversight, but there's still a long way to go, says lawyer Paul Chan.
If the RCMP doesn't even, pay proper respect to the public complaint process, it makes you wonder about, how they're treating the rights of Canadian citizens in other circumstances.
Welcome to Nation to Nation. I'm Brett Forster. An agreement in principle to reform the First Nations child welfare system was reached New Year's Eve, and so was an agreement to compensate its victims. Both were hailed as historic, but what could the settlement mean for thousands of families who suffered, struggled, and fought this system for decades? To find out, I'll speak with people who stepped forward to lead this lawsuit. First off is Zach Trout. He is an example of someone who couldn't access essential health services for his kids between 1991 and 2007 just because of where they lived. He hails from Cross Lake First Nation in Manitoba, but joins me from Winnipeg. Zach, welcome to the show.
Hi, thanks for having me.
So before we get into this settlement, can you share a little bit of your family's story?
Well, a lot of that has to do with drama and everything else, to relive all the hardships that we have faced in our community, because there's a lack of resources and programs in the community, and that's where all the hardships begin, because in the communities there's not enough resources available to meet the standards of living of disability of our children and the needs of our children.
Mm-hmm. And can you give me a better sense of what it was like for your family trying to navigate these systems that clearly weren't designed to help First Nations people living on reserve?
Well, to deal with children with special needs and with any kind of disability, that they require certain levels of care. And with our children, it was a level 4 care. It kind of like more into a setting of a palliative care to provide the needs of our children, which requires a lot of hospital settings within them to meet the needs of your children that are going through all of this hardship. Like we had to administer physiotherapy, all this kind of, we had a suction machine, oxygen machine, and a feeding machine, all these things, and an oxygen. We had to monitor all our children closely, like what they do when you're admitted in the hospitals. But with us, we had to do it basically on our own, 24-hour care, which was a lot of hardship for us to go through all that. Mm-hmm. Especially in the communities that there's no resources available to meet the needs of a level 4 case. So we had to basically step up on our own and to meet the needs of our children, because we love them so dearly, and it's pretty hard for us.
Yes, I understand your children, two of them, Jacob and Sinai Trout, were diagnosed with Batten disease from a young age, and which is a rather rare disease. I understand you've got some mugs with their faces on them. Perhaps you could hold them up and show us and tell us a little bit about how this impacted their already fragile health.
Well, Batten's disease is kind of a neurological disorder which kind of takes the toll on the children at the early age, because there's certain levels of Batten's disease. But with my children, it was late infantile syndrome. It kind of relates and stems from a neurological kind of just slowly deteriorates in the process of all their development. and all of their like their developments of how they like, you know how a normal child develops into a, like they start to crawl and walk and all that kind of stuff. But with this Patten's disease, it kind of takes a toll on them because they start losing their developments by walking, their speech, their motor skills. They slowly deteriorate into a process where they kind of just leads to bedridden, and it kind of leads to fatal in a late terms. But with us, it was so kind of, for me, it was kind of fast for us to kind of handle all that. And with all the lack of the resources available and all the needs that we needed to, for the basic needs of like the feeding bags, the syringes, and all these kind of stuff, the medical supplies that we required were kind of short for us to kind of reuse all of these stuff. It kind of makes it more harder for the children that are going through all of this, because they slowly start developing some kind of infections and all this stuff, and it starts to lead more into seizures and all kinds of other more complications.
And so why did you eventually feel it was important to join this legal battle?
Well, I was kind of I was living through all of that drama back in the day, and I was trying to regroup myself to a point where I would be strong enough to take a stand. But not only I wanted to take a stand, I wanted to take a stand for the children that are still going through the same suffering in our First Nations community. And I hope that this thing kind of helps to kind of add more programs and services that are needed in our communities. That's the reason why I took a stand, because I still see children that are still suffering today, which they shouldn't be, because we're already on a 2020 year, which is supposed to meet all the adequate services in the communities already.
Initially, the federal government wanted to oppose your claim because Jordan's principle, which is supposed to prevent this kind of jurisdictional fighting, didn't exist yet. But they changed their minds, and now you stand to receive some compensation. What was your reaction when you heard a deal had been reached?
Well, at first I was kind of overwhelmed. I was kind of surprised because I was ready to go into a battle with this, because I wasn't in it for myself or anything else like that. I was in it to try to improve the lives of our children, because all the time we say in our communities that every child matters, and it takes a whole community to raise a child. So in this country that we live in, that the government is reliable to meet the needs, the standards and living of every child in this country. Doesn't matter what the race may be, but they should roll up their sleeves and start realizing that there is a much need for children right across this country that are still suffering today.
Finally, what would this compensation and reform mean to you personally and to your family?
It will not ease all the pain and the drama that we incurred, that's for sure, because we're still living through that drama. But it'll help in a way that it kind of help sustain of all the suffering and all the things that we have went through all the hardships and everything else. But it will not erase anything at all, because we're still going to be living through all that drama that we have faced and that we have incurred.
All right, Zach, we'll have to leave it there. I do want to thank you for your time.
Yeah, thanks for having me.
Coming up after the break, Jonathan Miyawasaki joins me to talk about his brother Jeremy and their family's long fight for justice under Jordan's principle. Welcome back. Jeremy Miyawasaki has needed round-the-clock care his whole life. The 27-year-old has hydrocephalus, cerebral palsy, spinal curvature, and autism, but because he lives on Pictou Landing First Nation in Nova Scotia, his life has been a constant fight to get critical home care. Jeremy's mom, Marina Beadle, fought fiercely for his rights under Jordan's principle, but sadly, she died following a stroke in 2019. One of the last things she did was add Jeremy to this lawsuit as a plaintiff to represent people with similar stories. Now her son Jonathan is picking up his brother's cause. Jonathan, welcome to the show.
Hi.
So what went through your mind when you found out Canada had agreed to settle this case out of court?
There was a lot of times where the government would still continue to fight her, like they would appeal it. So it's that's what I'm kind of a little bit skeptical about, where they could still change, the government could still change their minds on the deal.
Eventually your mom and the band council sued Canada over this and won. The judge found that because Ottawa refused to pay for Jeremy's home care, this violated Jordan's principle. Has it become easier to use the program and get the things you need 10 years later?
From right now, it has been getting a little bit easier to get funding for Jeremy to stay home. He would there was a lot of other options where they wanted to put him into a home, but like a group home, but a group home wouldn't suffice for him as being in his home. So that would cost a little extra funding, going like 24-hour assistance, 24-hour care, having people come into the home and assist him, because he does need help getting around, and he does like there's a lot of care that goes into caring for Jeremy.
And what would the compensation component mean for him? Would it enable him to remain at home?
Yes, very well so. He would get the extra things that he would need to, like, stay at home. Let's just say, like, one of them, he would in through the house, his home would, like, bars would be, like, accessible for him to walk through. And like a matted kind of room. I forgot his company right now, HCRS, that stays with him at the home. They call it like a relief room, I think, or something like that. It would really benefit him in his, like, it's like a stress room or something like that, they called it. Mm-hmm. And it would benefit him to have a room like that where he can relax and, mm-hmm. And like sometimes he hits himself, like, not like whenever he's has his moments or whatever, and it'll stop him from really physically doing damage to himself when he's in those kind of moods.
Mm-hmm. Your mom certainly blazed a trail for a lot of other people, so many other families could access this program. By stepping in, are you planning to continue her advocacy work a little bit?
Yeah, actually, I do want to keep continuing what she believed in, everything that she believed in. I want to try to go the same route. She has some really big shoes to fill, but I know I can't fill them as much as she did. She really, really enjoyed. She really loved children. Really, really loved children. She looked after a lot of children growing up. Many different people she took in as her own, and she's just, I can't fill her shoes, but I can try.
All right, Jonathan, I'm running out of time, but I want to ask you one last question before I let you go. You know, what do you hope this settlement leads to for other families in the future?
I'm sure, hopefully, that this will benefit everybody in the future. All the children, keep them home at least, and hopefully not go through like the pain and stuff that we kind of had to go through. There was a lot of times where we didn't know where the money was going to come from, or a lot of times that we struggled to even keep things on the table for the three of us, and it was always just the three of us growing up, and hopefully this benefits more children and keep children home with their families.
All right, Jonathan, I want to thank you for your time.
Thank you.
After a short break, we'll talk about a recent court decision that found the RCMP broke the law by being too slow responding to complaints. Welcome back. The federal court has found Canada's top Mountie broke the law by not responding to a complaint filed back in 2014. The British Columbia Civil Liberties Association had alleged police illegally spied on advocates opposed to the now cancelled Northern Gateway pipeline. The Civilian Review and Complaints Commission investigated and delivered an interim report in 2017, but 3 years later the Mounties hadn't even looked at it. So the BCCLA sued the force over the delay and won. Paul Champ was counsel for the group and joins me to break it down. Welcome to Nation to Nation.
Nice to meet you, Brett.
So what is in this ruling and why is it important?
Well, the big thing here, Brett, is that the RCMP has had problems for well over a decade of systemic delays in failing to respond to public complaints. The RCMP Act creates a mechanism for Canadians across the country, coast to coast, to make complaints if they feel that the RCMP has mistreated them, all kinds of different misconduct, whether it's false arrest or not investigating a crime or treatment in cells, all kinds of different very important issues. And the problem we've seen is that these complaints for years have just piled up on the RCMP commissioner's desk without a response. And that's really frustrating or obstructing the whole process. So that's why we went to court. We felt that this was just unacceptable. And frankly, we thought the RCMP commissioner was breaking the law because clearly the statute requires some form of response to these complaints.
So what does it say about police accountability in Canada when it takes nearly 7 years and a lawsuit to get the Mounties to respond to complaints?
Well, I think it is sort of a sad commentary on the situation of the RCMP today. I think it demonstrates, I think what we see sometimes at the RCMP is a bit an attitude of impunity, a culture of indifference or complacency when people raise concerns with the RCMP. And, at the end of the day, it's about public confidence and trust in the RCMP. If they're not willing to look at public complaints seriously and treat them with the seriousness and the respect they deserve, it undermines the confidence of Canadians in the RCMP's ability to do their jobs.
Well, you've got a favorable decision here. What do you hope it achieves moving forward?
Well, like I said, we led evidence showing that for well over a decade, there had been serious delays in the process. Complaints would be sitting for years, 2, 3, 4 years. And the court now ruled that the RCMP must respond to complaints within 6 months. So that's, a huge victory for accountability of the RCMP. And, we will continue to monitor it and ensure that the RCMP is respecting this court decision.
How optimistic are you it'll actually happen going forward? The RCMP commissioner issued a statement recently saying that it is complex, but they do plan to address this.
Yeah, well, since we started the lawsuit, they hired new staff and they were working very quickly to try to clear the backlog. And by the court date, they were trying to argue to the judge, well, look, we've cleared the backlog or almost cleared the backlog, and so it's all good. But the issue is the backsliding, right? So, had we not pursued this case, it's clear, number one, that they wouldn't have cleared the current backlog. But now that we've won, this court ruling will stand as a precedent and a big club to ensure that the RCMP does respect the law in future and respects the public complaint system, because, at the end of the day, oversight is a cornerstone of a democratic society. If we don't have proper oversight of the RCMP, civil liberties are at risk.
Mm-hmm. The CRCC has delivered a couple of these reports that were just sitting there. Among them, investigations into the force's crackdown on anti-fracking protests in New Brunswick and its treatment of Colton Boushie's family were both quite critical. So would you say the oversight is starting to improve?
Yeah, those were both complaints that were, in fact, outstanding for a few years. And it wasn't until our lawsuit that the RCMP finally got cracking to complete those reviews and complete those reports. Now, I'm not saying that people are happy with all the findings in those reports, quite the contrary, but it's an important step around transparency. And, at the end of the day, if the RCMP doesn't even, pay proper respect to the public complaint process, it makes you wonder about how they're treating the rights of Canadian citizens in other circumstances.
Mm-hmm. Can you give me a better sense, as you just mentioned there, of why people still are somewhat discontented with the contents of these reports?
Well, even the report in our case, we weren't totally thrilled by the findings of the CRCC. We learned for the first time that the RCMP was absolutely spying on environmentalists and Indigenous peoples who were advocates for, climate justice and stopping Northern Gateway Pipeline. They were infiltrating church groups. They were going to church basements where people were painting protest signs. They were taking down driver's licenses. They were creating files on people who were going to different protests. All of those activities, while the CRCC expressed some concerns about it, they didn't say that it reached the threshold of misconduct. We strongly disagree, but at least these practices have been exposed. We now know for a fact that that's what they were doing, and we can start engaging, in the public debate with, parliamentarians, the government, the rest of the public about how these kinds of practices are completely unacceptable because they do infringe the right of people to protest, express their opinions, assemble, and that's what a democratic society is all about.
All right, Mr. Champ, on that note, we'll have to leave it there. I want to thank you for your time.
Thank you very much, Brett.
That's it for tonight's episode of Nation to Nation. If you'd like to learn more about the child welfare class action we discussed earlier, go to the SOTOS Class Action website. I'm Brett Forster. Thanks for watching, and have a great evening.